A question that a lot of people have is in Massachusetts about children testifying, whether that generally occurs or not. And in probate and family court, almost never will the judge allow the child to testify, and typically they don't want the child to even be in the courtroom because of the impact that that can have on the child and not putting the child in the middle of things. There are other avenues where the child's voice can be heard. You can ask to have an attorney appointed for your son or daughter and ask them to, it's called an ARC attorney, which is a pro bono, meaning it doesn't cost anything attorney. If the judge appoints that person, that attorney will meet with the children and will advocate for the child's position. You can also ask that a guardian ad litem be appointed, and the guardian ad litem will make a report, including an interview of the child, and the judge will be able, along with the parties, to read what the guardian ad litem has to say, or a probation or family service officer can also interview the child and make a report for the court. Usually the family service officer or probation officer is a more limited report, and that many times will just be speaking to the child. And whether it's a guardian ad litem, ARC attorney, or family service officer, they'll generally want to meet with the child alone in order to see what the child has to say. In juvenile court, there are some circumstances, they're fairly limited, where the child can testify, but sometimes the court will put limitations on that, meaning that it will be in camera in the judge's lobby, or the judge will be the one that will ask the questions, and the attorneys will have to write the questions out ahead of time that the judge will either approve or not approve. But again, even in juvenile court, the courts typically would prefer the child's testimony to come in another way. And there can be points where an attorney can be appointed for the child, where either a guardian ad litem or court investigator can interview the child. But in juvenile court, there are some more exceptions where the child will be able to testify and where the child might be more likely to be able to be present at the courthouse. The juvenile court is generally a closed courtroom session, so a lot of times the courts are more willing to allow the child to testify or to be present at their court hearing than they are in probate and family court.